Afternoon, good evening it is. Welcome to the State Senate Health and Human Services, and we got our screen going. Uh, Senator Robertson, Majority Whip, would you mind opening us up in a prayer? You're on number 8-9.
Yeah, yes, sir. It looks like a room that could use some prayer. We have to do that. Dear Heavenly Father, we come before you today, Lord God, as your humble servant. We ask, Lord God, that you open our hearts and our minds and remind us, Lord God, that we're here to be compassionate and caring, that this is not about us, but about those we serve. I ask during this committee, Lord God, that you keep us focused and that you keep us compassionate to those who present and to the members of this committee. We ask all these things in the name of your Son, our Lord and Savior, Jesus Christ. Amen.
Thank you, Mr. Whip. We're certainly happy to be here. This is our last meeting, and therefore our chairman of Judiciary, who is on Health and Human Services, been a pleasure having you. This is your last Health and Human Services meeting. Thank you for being here. Yeah, it is. So the author of HB 1296, Representative Monahan, we're going to work on that off session. He asked that we continue to work on that, so we're going to take that off the agenda. And because of the late hour, I'm going to go ahead and let's do HB 1393. We have a substitute, and we have some folks, just a couple folks that are going to testify. We're going to keep everything brief tonight, and then we'll probably do next is we'll bring back HB 350 off the table, and we'll have someone quickly testify there. And I think hopefully we'll not have anyone else testify except maybe obviously the authors. So we're here. If I could get Mr. Belafonte, if you don't mind coming up. So HB 1393, as we discussed in the hearing only last week, if you'll note that that bill, it's going to be threading the needle on this of whether we can get it done, Representative Werkheiser's bill, done where it passes muster when it comes to antitrust activity. And that's just a fact. I've heard that from everyone. All over the building, and I do mean all over the building. And the aspect of that is that I think that Mr. Belafonte has been working with the folks who originally wrote the bill and has got it to a good place, and it still may not pass muster when it comes to antitrust. I will tell you the Federal Trade Commission is also very attuned to this particular bill and this particular topic. And there may still be some more tweaks as we go along, some minor tweaks that we may hear about tonight, and then we may even have some changes in that. I will tell you specifically that this bill we added on, you'll see that we added on doing away with certificate of need with the exception of skilled nursing facilities. But let me be very clear. The message is that the bill that is in House Health right now, Senator Calvert's bill, is a cancer, doing away with CON for cancer. And how anybody cannot move or vote on a bill to make it easier for patients to get cancer treatment is just, I find that hard to believe. And let me just tell you what I've said over the years being chair of Health and Human Services, is that if we all do what's best for patients, then everything else will pretty much fall into place. So with that, Mr. Belafonte, if you will mind taking us through the changes, and then we'll have a little testimony, and then we'll go from there. Thank you.
Thank you, Dr. Watson. Josh Belafonte with Robbins Firm on this. I have focused on what is in the sub LC 521109S. Is that correct? Okay. Part 3, which is what I talked about on Monday, the antitrust side. I believe part 1 is the repeal of certificate of need. It takes up a lot of space because it's in a lot of areas of the code, not just 31 as well. And it would be, as you say, repealed for everyone but skilled nursing facilities. And then part 2, I'd actually that would be there as well. And then so part three, if I can go there, the antitrust, because there are significant changes in terms of text, in terms of structure, but what it really tried to do, and look, you're going to have three lawyers give you an opinion, you'll get at least 9.
And that's on
probably.
page 47,
So-
part 3, 1178. Is that
Yeah.
correct?
Yes. And so I fully expect, particularly in anything involving healthcare or antitrust, to get plenty of opinions one way or the other. And nothing is really clear on this because the Supreme Court has decided recently and changed some of the state action doctrine in a March 5th decision called Gillette. So some of this we just don't know. But the structure is Section 3.1 is in your existing Hospital Authorities Act. That starts on page 47. And it just adds the definition of rural hospital authority will be a hospital authority for purposes of Article 4. So we're not changing anything in the existing law on Article 4. The Section 3.2 is the provision now where there is antitrust immunity that the Supreme Court said was insufficient given the breadth of the code on this issue. And it makes clear that a rural hospital authority that exercises power as set forth in the new article, Article 4A, which is just about rural hospital authorities, that they have the immunity too. So you didn't want a situation where you grant a new immunity in one section and you don't change the old one, and somebody would say that the old one doesn't apply. It's really trying to keep Article 4 as it is. That gets you to Section 3.3, which is really the new part of it. Going through the structure of this one as opposed to the other is really 31.7.100 takes all the findings and policies that were scattered in the other one, puts them in one code section. There are most of the findings and policies from the original version that passed the House are there. There are some new ones to reflect what is the healthcare market today. The section Code Section 31.7.101 starts on line 1257. It is the new section of definitions. And the key one here is rural hospital authority. There's several things that a hospital authority to qualify for the immunity needs to have. It's not enough just to be a hospital authority hospital in a rural county, because I think we can all agree that there would be a difference between an independent rural hospital authority or one in a small group and one that is part of a large system, whether based in Georgia, whether based somewhere else, or whether only in Georgia. And so as this bill defines rural hospital authority that would have the new powers, it has to be located, it has to be a rural hospital authority, whether restructured or otherwise. And restructured is when you have the operating 501c there. It has to be located in a rural county or operates only in a rural county, affiliated with no more than 2 other hospitals. So you limit it to 3 to have the exemption from immunity. The immunity from antitrust, and not be affiliated with a non-rural hospital or suburban or urban hospital. So if you had a rural hospital authority that is part of a large system, and that large system has a hospital anywhere in a urban or a suburban area, that's not a rural hospital authority for purposes of the antitrust immunity. And again, it was from listening to the testimony, and if the purpose of the bill is truly, and it makes a lot of sense if it's this, to have the small hospitals be able to coordinate so that, if one has the urologist but one has the scan, they can talk to each other and share resources. And if that antitrust is the problem, then limit it to that issue, not a larger or more broad one. Section 102, Code Section 31.7.102 grants this additional authority to the rural hospital authorities. It's already largely in the other, but and this has got very similar, if not the same, language from the other 2, although all of it continues to limit it to rural hospital authority and rural hospital authority, not the larger systems. 103 is the actual provision of the immunity, while that is from the other one as well, and tries to carry that over as opposed to, again, doing it in several different places. 104, starting on line 1349, is the who gets the immunity. That's a provision from the other one, from the as passed version as well. and also makes clear either both, I believe, here and in another one, that this bill, while speaking of state actors and instrumentalities of the state and so on, is not granting sovereign immunity to public hospital authorities. They're not going to be treated as the Department of Community Health or something of that nature, or a county itself, but still having the immunity across from antitrust. So 317105 is deciding, again, what the limits of the authority are on. And this is really trying to say you're getting this immunity from antitrust, but again, not sovereign immunity, not if you're in a large group of hospitals, et cetera. So it's trying to be very clear about where the immunity is going to be, because when you grant this state actor immunity, you're declaring these entities parts of the state. And the phrasing that the Supreme Court said is you have to say that you are displacing competition in a particular location. And so the idea is, if you're going to do that, to allow this kind of cooperation, that can be as narrow as possible. Code section 317106 is a process, because it was thought that not every rural hospital authority that could qualify for this necessarily wanted it. There are things that, if you are deemed a state actor, and if it goes all the way to the county level, you could be liable for things like constitutional violations. If you're a government, you have to comply with equal protection. You have to comply with the First Amendment. And so this is limiting how and where that would be, and trying to be consistent with the other and give the hospitals a chance to say whether they want to do this or not. And effectively, it follows a notice procedure somewhat similar to other provisions we have. This starts at line 1405. A hospital that chooses they want to avail themselves of the immunity would provide notice to the Attorney General, the governor, the chairs of the Judiciary and Health Committees of the legislatures, the Lieutenant Governor, and the Speaker of the House. The AG would have 180 days to determine if the hospital qualifies, if they meet that definition of rural hospital authority. They would have the ability to request documents, and if the documents are not provided, the request is not. And it would also any person within 35 miles that is a healthcare provider can provide information to the Attorney General and say, we don't think this person meets it. The Attorney General gets to decide that. No particular hearing, it's just they have additional information. Anyone can then, if the Attorney General denies it, the applicant or the rural hospital authority can challenge that in court pursuant to a fairly limited procedure. If you were in that 35-mile radius and a healthcare provider, you had to provide opposition to the Attorney General in order to get to court. That's fairly standard what we do in administrative things. And if you were not one of those, then you could challenge it later. And then you have to annually tell the Attorney General and DCH that you still qualify, because there's going to be transactions that happen over the course of the year that's there. And with that, I think that's what covers the sections of the bill.
Thank you so much. So the first part of the bill, as Mr. Belafonte noted, was the certificate of need. So you're establishing an antitrust in immunity in a up to three hospital system there. And that was where certificate of need would add on a significant monopoly for that particular aspect of that. So I'd like to go with a little bit of testimony before we do questions and voting. So we can get, let's see here. I can't read your writing. Hold on. One with on Zoom, Ms. Geddes. Is that you, Ms. Geddes? Did I pronounce that correctly?
Yes, you did.
Okay. Thank you so much. You're now front and center for us. Thank you. And
thank you, Chair Watson and members of the committee. I'm happy to be here this evening. My name is Ailey Geddes. I am an assistant professor of economics at the University of Georgia, where my research focuses on competition in healthcare markets. I'm here today in my personal capacity as a researcher and expert in health economics, to share what the economics literature tells us about the impact of certificate of need regulations in rural communities. I want to be clear up front that I'm not speaking on behalf of the University of Georgia. So let me start today by describing what certificate of need laws do and the reasons that they were enacted.
Ms.
Certificate
Geddes,
of need law.
I do want to be clear. We do want to hear from you, but it is late. I know it's 7:20, so if we can be real brief, that would be much appreciated. Thank you so much.
Okay, I will try to be brief. Okay, so these regulations require healthcare providers to get state approval before they open new facilities, they add beds, or they add equipment. The idea here was that the state would act as a gatekeeper to prevent wasteful duplication of service and to provide some financial benefits from existing healthcare providers, particularly in underserved areas, to make sure that they remain financially viable. And so I'll tell you a little bit about the empirical literature on these two potential benefits. So the initial claimed benefit of certificate of need regulations is that they reduce wasteful expenditures. It was a major policy concern at the time these regulations were enacted that there would be duplicate provision of costly medical equipment and that the presence of such equipment would lead healthcare providers to induce demand for medical services, leading to increased healthcare spending. So the classic argument was Romer's law that a hospital bed built is a hospital bed filled. I think it's important to note here that this argument was developed at a time when there was few other healthcare utilization management systems in place and where payments were largely made on a cost plus basis. So providers had little incentive to control costs. Payment policies have since shifted, and today we have a lot of other tools through which we can manage costs. The empirical research on this particular benefit finds little evidence to support the claim that certificate of need regulations lower costs in practice. Instead, certificate of need regulations can often result in higher expenses for patients because they reduce competition. A meta-analysis conducted by Mitchell in 2024 finds that the majority of studies on certificate of need laws find either no association with spending or increases in spending. So it does not appear that certificate of need laws have achieved this first goal of containing costs. So this brings me to the second claim benefit of these regulations, that they provide a financial benefit to existing providers in underserved areas, which could be used to cross-subsidize unprofitable services. It's crucial to understand here that there's a large trade-off associated with this financial benefit the state provides incumbent providers. The additional profitability that incumbent providers receive from certificate of need laws is the result of restrictions on entry by new competitors and represents the result of decreased competition in healthcare markets. A large body of work in health economics shows that competition in healthcare markets, just like other markets, promotes lower prices and higher quality for consumers and encourages innovation. Critics, including the Federal Trade Commission and Department of Justice, have long argued that certificate of need laws function primarily as barriers to entry that protect incumbent providers from competition rather than serving patients. The empirical literature here suggests that certificate of need states tend to have less capacity and in some cases worse access than non-certificate of need states. A 2025 review of the economics literature by Corton-Manchi and Garuccio found that states with certificate of need laws tend to have fewer hospital beds per patient, and less access to imaging services relative to states without such laws. Furthermore, contrary to claims that such laws protect hospitals with high indigent care burdens, as part of that evaluation of Illinois' certificate of need laws, the Lewin Group found that safety net hospitals in certificate of need states had lower margins than in non-certificate of need states. There's additionally a structural concern. The review process itself can be captured by existing providers who both have the incentive and resources to challenge competitors' applications, regardless of whether those competitors would actually serve patients well. This aspect of certificate of need regulations amplifies the anti-competitive nature of the laws. In closing, certificate of need laws in Georgia and elsewhere were enacted with genuine policy goals in mind, controlling costs and protecting providers in underserved communities. The evidence suggests that the first goal has largely not been achieved. The second involves a real trade-off. Financial protection for incumbent providers comes at the cost of competition. And competition is one of the most reliable mechanisms we have for improving quality and controlling costs in healthcare markets. I hope this committee will weigh these trade-offs carefully as you consider the future of certificate of need regulation in Georgia. I'm happy to answer any questions.
I'm going to hold on questions, but thank you very much. I appreciate you bringing that to us. I think it just sort of drives point in a very logical manner, unpolitical, apolitical, and I really appreciate your thoughts on this. And hopefully we can have you back in the future when we have a little bit more time. And lastly, go Dogs. All right. Thanks so
Go
much.
Dogs, and I'd be happy to come back anytime.
Thank you. Next, we have actually one more on Zoom. Jim Manley. Is that you, Jim, right there?
Yes, thank you, Chair Watson.
Okay. The floor
Can you all
is
hear me?
Yes, we can hear you well. So if you can be brief like Ms. Geddes, she did a great job. Just brevity is your friend. Thank you.
Yes, sir. I think I can actually be even briefer because Ms. Geddes did a wonderful job summarizing the empirical research. And so I'll just highlight some of our experience on the legal side of things. I'm Jim Manley. I'm the director of state policy for Pacific Legal Foundation. PLF is a nonprofit law firm that represents individuals when their constitutional rights are violated. We do so free of charge. We've litigated more than 2,400 cases, including 18 wins in the U.S. Supreme Court, and including several cases in Georgia. Part of this work involves PLF representing healthcare entrepreneurs who want to provide needed services to their communities, but are unable to do so because of government restrictions like certificate of need laws. These are regulations that are not related to public health or safety. They're simply aimed at protecting existing healthcare providers from competition. Our client, Katie Chubb, is a midwife in Augusta who tried to open a birth center and was stopped by hospitals that didn't want the competition. Several years ago, in a different role, I represented two doctors who simply wanted to let other doctors use their surgery center while my clients were busy at other parts of their practice, and they were vetoed by the hospital across the street with the help of Georgia's con laws. And in that case, the Georgia Supreme Court said it was up to the legislature to repeal Georgia's con laws, and I hope that is the step that this committee takes tonight to move one step closer to that. The con process, as I said, has nothing to do with health or safety. It allows competitors to veto new services. And then even worse, it allows those competitors to challenge approvals if the Department of Community Health decides to issue the con anyways. And so just one illustration of that, every week DCH publishes a con tracking report that lists all the pending con applications. The list that was published just last week includes a con application that was approved in July of 2020. And it was challenged by a rival hospital and remains on appeal now almost 6 years later. That is the pace of change under the Certificate of Need system. And as Professor Geddes explained, decades of research show that con laws lead to decreases in access to care, higher healthcare costs, and lower quality of care. And I just want to highlight the impact that has on rural care, because I know that's an important issue in Georgia. A 2024 study concluded that rural areas saw the biggest increases in access to care and no associated harm to rural hospitals in states that repealed their con laws. Rural healthcare benefits from repealing con. And that's part of the reason that the Senate committee in 2023 in Georgia recommended that the General Assembly fully repeal its con laws, the 2023 con study committee. And we know, looking at other states, what repeal looks like. Pacific Legal Foundation helps on these issues across the country. In 2021, Montana repealed its con laws. And since then, research has shown that services that were previously covered by con have grown by 12.5% in just the last 5 years.
All right, Mr. Manley, I'm, for interest of time and we got everybody here and I just don't want people to go. I get it. Both of y'all are saying higher prices, lower quality without the competition. And you have driven it home, and I can give examples in my community, and I think everybody can give those across the state. thank you so much for being here, and I'd love to have you back again in the future. You're certainly
Thank you. It's my pleasure.
much appreciated. Thank you. The Chris Denson, I hope, Chris, do you mind for time of brevity? I think you're in support and
Of this CON provision, and I look forward to reading the revised version of the Hospital Authority.
so Chris Denson's with,
Chris Denson, Georgia Public Policy Foundation, and Georgia Policy Impact.
thank you.
Thanks, sir.
And then Jesse Weatherington, did you have anything further to offer from our hearing on Monday? Yes, please. Jesse Weatherington is with the insurance. I don't know what is the name of your group?
Georgia Association of Health Plans, Mr. Chairman.
There you go.
Thanks to the work of Mr. Belafonte, many of the antitrust concerns we had about the underlying House Bill 1393 seem to have been mitigated. And coupling that with a full bore certificate of need repeal, we think the benefits of that would more than outweigh any harms. I would urge the committee to support the substitute. This will be one of the most impactful votes you take as a senator to help improve the health and welfare of the state of Georgia.
Thank you. We have Anna Adams, unless she wanted to waive for, I think Michelle Madison wanted to also speak. I think she'd worked with Mr. Belafonte, and they're certainly welcome.
Thank you, Mr.
Thank
Chairman. I separately, Anna Adams with the Georgia Hospital Association, we appreciate the work that has gone into the underlying portion of House Bill 1393. I know that we had some questions from some of our members about how that would work, particularly with relation to how those hospitals would partner. And so thank you for that. In addition to that, we do have opposition to the complete repeal of certificate of need, sans nursing homes. We were happy to work with you on previous legislative efforts that have gone through this process, but this one is a little bit further than what our membership is comfortable with.
Thank you. I understand that.
Thank
And we started this out with, probably wouldn't be here if the House Health had not, heard and voted on the cancer one. So really appreciate.
Understand.
Thank you so much. And then, and I think Michelle Madison didn't sign up but wanted to speak. And I think, and we're happy to have you. We really appreciate you working and fine tuning the rural hospital, because that's why we're here today, is to try to fine tune this and thread the needle and get that done. Thank you for being here.
Well, thank you for having me. My name is Michelle Madison. I'm with the Bradley Law Firm, and we did work on the original bill, the Antitrust Council that we have. I'm a healthcare attorney, not Antitrust Council, but the Antitrust Council did work on this bill. And originally, and I'll be brief, the focus was really focused on the rural hospitals. I work with about 30 of those rural hospitals in our state. And the concept was to try to make sure that our state law had the right language for the state action doctrine when those hospital authorities can collaborate together in rural areas to cut cost. And one of the reasons that we were so focused on it was the Supreme Court decision that came down and said Georgia law needs to have these provisions in it, which is why the original bill had those provisions from the Supreme Court decision of 2013. But the other reason was because the Rural Transformation Fund is happening in our state. And we do want to make sure that as we move towards a total cost of care, which means that the rural hospitals are going to get paid one price in 2029 if they all elect to go in for the care they deliver to Medicaid, Medicare, and other third-party payers. And when that happens, in order to stay economically viable, we've got to reduce the cost. And so today, if a rural hospital has imaging, and I shared this with the House Committee, has imaging at one hospital and a surgeon at the other, and we don't want to duplicate those costs, being able to tell patients, go to this facility 20 miles away for imaging, go to this facility for surgery. We can't do that today. We can't quid pro quo it.
And it's real important when it comes to the rural health transformation. I just got the number on that. I think that's 218 million. I think we talked about that before, every year for 5 years, so over $1 billion. And to be able to coordinate that, I think, is important for rural hospitals. I think that's good. We are talking about the Georgia Strong DPP and Georgia Strong #2, and we talked about eligible hospitals, but we're talking about major numbers: 586 million 2025, 746 2023, 865. So that's Georgia Strong. And then the eligible hospitals, also in the teaching hospitals, 1.9 billion for our DPP2. So
Yeah,
anyway,
there is a focus on making sure that hospitals who have residency programs will have funding because we have a shortage of workforce in our state and a shortage of physicians.
and
So promoting the residencies is going to be important. At the same time, we have a shortage of nurses and physicians across our entire state, but especially in the rural area to be able to recruit those specialists. And so I did talk with Mr. Belafonte about the revisions that were coming into this substitute bill. And the concerns that I have are related to some of the restrictions. I think this provision related to the antitrust, and I think Anna spoke to where the hospitals are on the CON side. But on the antitrust side, some of the language limits it to 2 rural hospitals being able to work together. Today, I think 2 rural hospitals could work together without violating the FTC. We can't do quid pro quo. But it's really a collaboration of providers to come together for group purchasing and to be able to recruit and to get specialists from some of the actual metro areas to come to the rural areas and provide care. They're not going to do that on a full-time basis because we might have 6,000 people in our community, not 400,000 people. And so part of the law that's drafted in this bill that came as the substitute talks about we can only partner with rural physician practices, and that's going to cut out the cardiologist and the urologist and the GI guys that we do need to come in to partner with us in the rural areas. So I am requesting that there be some reconsideration and that we don't pass the substitute bill because I think that the substitute bill, while I appreciate Mr. Belafonte's efforts, has some concerns related to the limitation of just 2 hospital authorities working together, limiting it to rural physicians only, and then the administrative process that if they do want to use the state action doctrine, we have to go to the state and say, hey, we want to use the state action doctrine. Here's all the filings. It's like going through a CON to use the state action doctrine. So the administrative expense there for these rural hospitals will be extreme. So I'm requesting that we not move forward with the substitute bill. And obviously, the first 48 pages of the CON, I let Anna handle that part. But I
I
appreciate
got you.
I
Thank you so
appreciate all the
much. And
communication. and the
you're
opportunity.
with law firm. You're not with GHA. Want to be clear.
I am not with
And I
GHA.
got you. And your law firm is
Bradley
Alabama
Aaron.
and here in Georgia.
Alabama, Tennessee, North Carolina, DC.
Okay, great. I got you. That's big. Okay, thank you so much.
Thank you. Thanks for
Appreciate
having me.
that. So I think that's where we are. Mr. Belafonte, do you mind coming back up and just to answer a couple questions, and then because we have members that need to leave, and we're going to vote in about 10 minutes or less. Thank you. Would you mind addressing what she had said about
Sure.
the?
Yeah, and I think, certainly a lot of this stuff could be fixed pretty quick. The one about, I'll just go through a few of them. The process on applying for the status is limited to 180 days with the Attorney General and then potential judicial review after that. It could be shortened on potential judicial review, but I think there's also a trade-off because on the CON side, you heard that's there, and it would be shorter than a CON because you have a 180-day at the agency level for that to happen without a hearing and then another one. On the physicians' practices being in a rural area, it's a good point that if the specialists aren't there, it can be expanded. That's a language piece. I think it was narrowed in order to prevent a backdoor again for kind of larger systems to enter through a physician group that they affiliate with, and you could still do that and have the specialists available or allow it only in specialist areas for that. And again, I think the idea that I didn't hear anything that couldn't be changed
I got you.
in terms of
Okay.
language.
So as we move forward, things can be changed.
Yeah.
And nobody's against, you certainly don't want to bar subspecialists coming into rural areas too. By no means.
Chairman, actually on that point, I'm very sorry, but I just want to make clear because I didn't discuss it before. A lot of the literature that you see, and this was talked about on Monday, is when you combine non-compete agreements, particularly with physicians, and they're applied in rural areas, it has a significant anti-competitive effect, and it makes it harder to recruit because if the urologist knows they have to sign a non-compete, and they're going to be out of that county and probably the next one after that. And so there is a provision in here that if the rural hospital authority chooses to take advantage of the immunity, they cannot enter into non-compete agreements with healthcare providers. That will keep them coming faster, we believe.
Okay. Question, Vice Chair. We're going to be quick. We're going to do,
This is just, I may need you to dumb this down a little bit about how we can get immunity from a federal antitrust law.
So the federal antitrust law does not apply to states. So for example, state psychiatric hospitals and things of that nature, antitrust doesn't.
so you're an organ of the state.
Correct.
Okay, that's the
Correct.
answer.
Yep.
Next,
Hey.
anybody else with a question? Senator Brass.
Well, Mr. Chairman, if should this become law and any part of this bill get struck down, is there a severability clause in here?
Goodness gracious, I tell you what, you're spoken like the guy sitting right beside you there. Severability there. Mr. Belafonte?
There's an severability in every bill the General Assembly passes, whether express or implied.
Okay, great.
Look at that.
Good question. From a non-lawyer, that's a good question. Maybe not from a.
I'm a
that's
doctor
right,
today.
right. That's right. All right. Senator Sesser.
Thank you, Mr. Chairman. This question about line 1389 and 1390 about these physician practices that again may come in periodically. If we were to change that to not apply any physician practice that is affiliated, and we change that is owned in part or whole by a hospital or hospital group, that would keep out. I think your concern was preventing hospitals in urban or suburban areas from finding ways to kind of
Trying to get the specialists in there.
Yeah.
Right. What line are you talking about?
1389, 1390. If you prohibited line 1389, 1390. Nothing in this article shall be construed as applying to a physician practice that you use the term affiliated with. I mean, I would think affiliated with is if you're an independent practice that's affiliated with a suburban hospital that now wants to go serve in a rural area, you'd be prohibited by this. If you said owned in part or whole by, then if you're owned by a hospital, that would seem to be the nexus of the hospital you're trying to prevent.
Let me clarify here. Is that, I mean, applying to any physician practice affiliated with any hospital or group of hospitals is not a rural hospital authority. So an independent group of specialists. I mean, because most specialists are now independent, partly because of the ASC-CON. They wouldn't be prohibited from coming.
They would not, but I think you could tighten the word affiliated, because someone could argue that includes clinically integrated networks where you
Gotcha.
share billing structure. So it could be employed by or part of a group, something of that nature.
I got you. Do you have a recommendation there? You want to think about it for a second?
I can certainly do that. And but if there's going to be, to address some of the things I think Ms. Madison raised, if there's an opportunity to continue working on the bill.
I think that's the thing to do.
Okay.
All right. Any other questions? Senator Orr? Well, the light's not working here in this committee. Sorry. Okay, you're in one.
I think you told me that,
All right.
that already. Thank you.
We got a
Thank you.
question,
Yeah.
not a
First
statement.
of all, I apologize, but 4 of us came in late because we were in Finance Committee. Mr. Belafonte, I don't even know who you're representing. That's number one question.
I've been asked to give a legal analysis of the bill, and so I'm doing it through my law firm. And so I'm not here on behalf of any client that I lobby for in the healthcare space or any other lobbying client.
I say thank you. In the remarks that have been made tonight from the UGA professor, et cetera, it's true, isn't it, that federal law requires hospitals, nonprofit hospitals, to take patients that present and not screen out. Is that right?
Federal law requires all hospitals, regardless of their tax status, to do that.
To do that. And so that is a reality that hospitals are charged with following that law, following that federal requirement.
Yes.
So if a surgical center comes in to do certain procedures, they call it cherry picking, that are procedures that are profitable to deliver, and that's what they sell. That's how they compete with the community hospital that takes everybody and has a large and they take the mix of the people that can pay over to the surgical center and leave a large group of uninsured and underinsured people at the hospital. And that is a fundamental reality of hospitals failing financially because the model doesn't work. How do you true that up when the hospitals have a requirement that they have to meet that a surgical center doesn't?
Sure. And, again, all hospitals, community, otherwise have
Exactly.
that requirement. So yes. I think in having gone through a bunch of CON debates since, I guess, 2007, the response to that you typically hear is that the surgery center is doing it for a far less price. And because the charges are less, the reimbursement is less, the hospitals are cross-subsidizing. They are charging more to make up for that other one there. The surgery centers
Up for what?
to make up for the patients that come in that are self-pay or no pay or have less. So that's why they're charging the insurance companies more than a surgery center was. They're also charging Medicaid more and Medicare more. So that's where it's recognized in terms of the what's called cherry picking that you hear a lot about. And no surgery center that I'm aware of, well, no private surgery center is tax exempt. And so that's another piece that is there, and those taxes then go to pay to help things like Medicare, Medicaid, et cetera. I'm offering what is kind of there in the literature and what's there on the years of debates on it. But
All right.
be the response.
Thank you, Ms. Belafonte. I'm ready to entertain a motion. Make motion do pass by the governor's floor leader who needs to head back up to his daughter's cheer practice. Got to pick her up at cheer practice. I got you. Got a second by Senator Setzler. Any further discussion? You can ask a question. Yes, ma'am.
I thought we were just saying that this bill needed more work and some more time. I thought I understood that.
I have, as the sponsor of this substitute, I am firm on that if we need to continue to work on this, we will work on it. And we have been, with Ms. Madison and so forth. We will. Absolutely. Thank you. So we'll either do it other places, or we'll swap it out, or we'll see what happens over in the House. And there are a lot of variables in there. Got a thumbs up. All right. All those in favor, raise your hand. 2, 3, 4, 5, 6, 7, 8. That's 8. All those against? 2, 3, 5. 8 to 5. The motion carries. Thank you. And drive carefully, young man. All right, so I have a grandmother that wants to testify on the next bill. She does not look like a grandmother, but we're going to take off the table House Bill 350. That was by Representative Cameron. He's back there. He raises his hand. Representative Cameron, you can come sit right here. And if you don't mind, Ms. Patterson, Jill Patterson, is wanted to give us a little quick testify. If you don't mind being brief, but
Absolutely.
I understand you drove up here just for this, and I really appreciate you coming, and
Totally
thank you.
understand. Thank you so much for giving me this opportunity, and thank you for staying and hearing me out. This is going to be very, very brief. My name is Jill Patterson. I am 50 years old. I've lived here in Georgia since I was 18 months old. I'm the mom of 5 astonishingly fascinating young adults, 2 of which choose to call me their mom, and 3 of which are mine by the grace of genetics. All 5 are impressive humans who are wildly different from each other, but together they've formed a tight bond. They are among the best of their generation, and I could not be more proud of them. I feel confident in saying that everyone in this room is either the parent of, the uncle or aunt to, or knows a young person that they know and care for as their own child. My family could be your family. On March 17th, 2020, just as the world was going into lockdown, a gentleman came to my door. He was unexpected, and we were trying to maintain social distance. We sat down with our coffee table between us. He asked me if I knew about a case from late 2018, early 2019 in Troup County, where a newborn baby had been found dead in a watermelon printed cooler on the side of the road. I was horrified, but I didn't know about this case. He explained that he was the detective in charge of the case and that the newborn's DNA had been linked to my family's. Within 3 minutes, I learned that I had a granddaughter and she was dead. I remember asking him if he had seen her. I remember the expression of remorse and the gentleness in his voice when he told me that he had and that she was beautiful with a head full of hair. I burst into tears. His face was full of compassion as he came to stand next to me and put his hand on my shoulder. Over the next 72 hours, we discovered that my son's high school girlfriend had hid a pregnancy, given birth in her parents' home in Troup County, and wrapped that healthy baby in a pair of sweatpants, zipped her into that damn cooler, and abandoned her on the side of the road. I have flashes of faces from that spring, the stunned faces of my children, who were in their late teens and early 20s at this time, at the realization that someone that they knew and that they loved was capable of being completely heartless. The solemn expressions and the kind eyes of the Troup County officers and detectives, who at least on one occasion legitimately held me up when I was absolutely woozy with shock. My husband in tears in the backyard on the phone with his mom. My 19-year-old son, who'd always said he couldn't wait to be a dad, curled up on his bedroom floor, face contorted and keening with a pain that I will never fathom. I will never forget that sound. I remember catching my own face in the rearview mirror as I tried to gather myself to drive my boy home after picking up his daughter. The small box cradled in his arms as if it were a baby, and not just her ashes. Since then, nothing has been the same. We struggle every year on December 28th, the day that Eliza Jane Warner was born. We struggle every March 17th, the day we found out about her existence. We struggle with the whys, with the what ifs, and the why didn't she's. I still stumble every time someone asks me if I'm a grandmother, because saying no feels cruel to a baby who is loved and who will always be loved, but sharing this story can be cruel to people who are not prepared. There are no simple answers for my family. Just the cold, harsh reality of what happened to our Eliza Jane. But there is a simple answer before you, ladies and gentlemen. I am here today, and I waited here today to speak with you and plead with you to approve the Safe Haven baby boxes outlined in House Bill 350. I will never know if having this life-saving device available would have saved our Eliza Jane. But there is a fact that over 75 babies that were born healthy and alive are here today because other states have approved similar bills. Please vote yes for Eliza Jane and for HB 350. Thank you again.
Thank you, Ms. Patterson. Really appreciate you staying. Thank you so much. All right, we'll do House Bill 350, which is off the table. Representative Cameron, we had pledged to you that we would bring her off the table, and we have some amendments, and what we're going to do, I think, is the best thing to do is we heard testimony on this Monday, and what we'll do is, if I remember correctly, gosh, hang on just a second. Let's do at ease.
I'd like to make a motion. HB 350 off.
All right, can you repeat that in the mic? You mind?
Sure, I'd like to make a motion that we bring HB 350 off the table.
All right, second motion. All those in favor of that motion, say aye. Opposed, like sign. Thank you. All right, so we're off the table, and so we need a motion to do pass House Bill 350, LC 560268, and so moved. Strickland.
Second.
Second, Brass, and Chairman Brass. So all those, well, before we do that, let's do the amendments. All right. I'm glad I got some experienced guys around here to help me out. So that's good. All right. So I got the order. It should be in your packet. We got AM 560063, AM 560072, AM 560069, AM 560068, AM 560067. All right. So and 70. All right, there we go. All right, so legislative council is familiar. So if it's okay, I'm gonna just have the author of the amendment. So we get, let's count those up. 1, 2, 3, 4, 5, 6.
Yes.
All righty. So if I'm gonna just have the author present it, and then we're going to vote it up or down. And
Okay, I'd like to start, Mr. Chair, if it's okay with you, with 0072. And this is basically financial issue. And there are two different parts. The first part does not add the boxes and all the other language about ambulances and so on to the responsibility financially for defects before they take custody of the child.
Okay.
And then the second part of that just confirms what you told us, Representative Cameron, before, that no state funds will be expended for the boxes.
and he's for the audience back there, I think they could see, for the million of people that are watching us online, then we can say if we saw you nod. Okay. All right. So any questions on that committee, from the committee? No questions. So we are accept a motion.
Yeah.
Motion
So
to
moved.
so moved. AM 560072. Second.
Okay.
Second. Senator Chairman Huffstetler. Any further discussion? Okay. If there's no objection, there's no objection to the amendment, then no objection to the amendment, then it is adopted. Okay.
You want me to do the next one?
0063.
6-3.
Okay.
Yeah, this one is basically these boxes are unsecured and they're in a secured environment like a hospital or a fire station or whatever. And so I feel fairly strongly, and I think some other members of the committee also do, that because the boxes are not locked in any way and that anyone can put anything in the box, that could apply to some criminal activity or some even terroristic activity. And so for that reason, I am trying to amend this to make sure there's a security camera on the outside box.
Okay. All right. So any questions to the author? Chairman Strickland.
To the author, is that, are you supportive of that amendment?
I think I understand. We had a nice discussion about that as far as if someone were to do some terroristic thing, you want to be able to have some kind of record of that.
As in like explosive device
Yes,
or
sir.
something like that.
Yes,
Yeah.
Mr. Chairman.
Right.
So looking at line 81 of the bill, you don't see a conflict there. If we had that amendment, then the line we have about this being located in an area that's conspicuous and visible to employees, that you don't see any conflict there, right?
No, sir.
Okay.
And you're okay with this? Yeah.
That's what.
So
So,
did we get a
yeah, so,
motion?
yeah, so I would move that we adopt 0063 amendment.
0063, have a second, Chairman Huffstetler. And is there any objection? No objection. And the amendment's adopted. And so I think the next, who's author of 0069 and 68?
Senator Setzler has all the next four.
Got all the next four. Senator Setzler, you had the mic.
Thank you, Mr. Chairman. I told the author of the bill, I know there's the big policy move here is about the baby box, but I also think this is an opportunity for us. A number of members are more comfortable with the existing safe haven law, expanding it smartly in a measured way.
Yes, sir.
You know, with the program that you're initiating, there will be a couple communities that do this. But most of the state's not going to have big boxes, so we think about the existing safe haven law. What this amendment 0069 simply does is right now the law cuts off the immunity from prosecution for the mom handing over a baby in this context to 30 days or younger. While I might like it to be more, I've proposed in this amendment extending that to 45 days. So if a baby is 40 days old, 42 days old, the mother could still hand the child over safely and have the protection of the law.
Motion, second, the discussion, the authors,
That's very reasonable.
that very reasonable. Okay. Is there any objection at all? No objection. I guess for the record, none. I got it. Thank you. Thank you, Senator Allrock. So the amendment's adopted.
Sure.
Which one you want to do next?
0067, if I could, please.
Okay. Floor is yours.
Things in order. Right now, the law stipulates that a mother could hand a child over, again, not in the context of the baby box. This is just the warm handoff from a human being to another human being. Could be in a hospital or a birthing center or county board of health. I'm proposing in this amendment to extend that to ambulatory surgery center or urgent care facility. Many of our communities have those. I have coordinated with the ambulatory surgery center folks who support this, and I appreciate their support. This just provides folks in communities that may not have a hospital, but they do have an ASC or urgent care facility.
Got it.
Or
Urgent care. Motion,
Move.
second. And any further discussion? And is the author nod his head? You're okay with that?
Yes, sir.
Expanding that. And is there any objection? No objection. So the amendment AM 560067 is adopted. All right. Do you want to do
0068, Mr. Chair.
0068?
Currently, the law specifies, again, for handing off, a warm handoff of the child to another human being, a police station or fire station. Often in the communities, there's law enforcement officers, there may be a police car, there may be a fire truck. Again, I talked to Senator from the 29th. If a law enforcement officer is present, they want to hand it off to a cop. Very often the police officer may just call an ambulance and have the child evac. It gives the ability, other than a fire station or a precinct, to be able to hand a child off safely to a responsible adult. The same that would be handling it in a facility, but just away from the facility. That's all this does.
Got it. Motion. Motion. Maybe I want to second this one. Second, Hufstetler and Chairman Hufstetler. Any further discussion? This was sort of brought up the other day, and we're talking about police officers, and I had a little reservation because I was going like, well, police officers, healthcare, but I got quickly reminded that they're going to hold the baby and call the ambulance or whatever. Gotcha. And wouldn't have to worry about a car seat or anything like that. So anyway, so you're in agreement with this, and is there any objection? No objection, and then that amendment, AM 560068 is adopted. And lastly, AM 560070.
Yes, sir, Mr. Chairman. One of the most, as we understood the testimony, I appreciate the author and the people that spoke to this. Biggest problem with a lot of the moms is sort of this sense of dread of facing people. What this includes is if there's somebody that assisted the mother or acts, again, specifically at the direction of the mother to help convey the child, they're not going to be prosecuted. If someone was, again, at the direction of the mother helping convey the baby, they have the same immunity the mother would have.
Like a good Samaritan kind of thing.
Yeah.
So like grandparent or
mom or sister.
Somebody assisting. What was it?
May have another one after we finish.
Okay, and motion. Second. And we are, any further discussion? You're good with that?
Sure.
And all those, actually, there's any objection? No objection. AM 560070 is adopted. And we may have one more amendment. He's working on it right now. So let's be at ease just for a second, and can I recognize you on number 9?
Number 9. Mr. Chairman, if there's no objection, I request that we amend the legislation and name the legislation after the child that was lost in Troup County.
I agree.
How would you style that? We
got a spelling right.
Yes, we just want to make sure we get the correct spelling. Child's name.
All right, that's a good motion and
And it was seconded by Senator Brass.
second by Senator Brass. We're gonna get the,
Yes, Chairman Crowe is getting us the correct spelling of the name. Excellent. Because of the way this legislation is currently done, by adding the baby's name into it, we would be actually placing the baby's name in code. So the baby's name would be in Georgia law. And if there's no objection from the family, then that's what my motion would be. Yeah. Thank you. Thank you. Thank you, Senator Strickland. Ledge Council has the.
Ms. Britton, we got the correct spelling and all. And Senator Chairman Strickland, you want to comment on that, please?
I want to clarify, we name bills after people, but that's just the act itself a lot of times that we
Right.
do. This bill, actually, the current law, I guess was enacted in 2002. It's called the Safe Place for Newborns Act of 2002. It's in the code, as you see on the first page of the bill. So it's a lot different, a bigger move, frankly, to actually name the whole act after the child. So make sure if that's what we wanted to do, we stated that for Ledge Council.
Yes.
Stand by my second.
All right, got a second. All right, any further discussion? We're all clear. I presume there's no objection. No objection, it is as amended. Thank you. All righty. Now I think we are going to vote on HB 350. Get the, can you show me the bill? So HB 350 LC 560268 as amended here in our committee. And we have a motion to do pass. Second. All right, all those in favor, let's raise our hands. How about that? All those in favor, raise your hands, and all those in favor, all those opposed, like sign. Okay, thank you. All right, so thank you. And who is carrying that?
Senator Strickland.
Senator Strickland, that's right.
And Mr. Chairman, may I make one point?
Sir.
Thank you for all the input and back and forth I've gotten from several members of the committee in the past week. I really appreciate your input. And thank you for your help.
Thank you, Representative Cameron. All righty. Chair Lady Taylor, you're up. Thank you. Chair Lady Taylor, you still look fresh and goodness gracious, and here we are. It's 8:09, and you're looking. Goodness, did you go home and take a shower and get dressed again?
No. Thank
Yeah.
you, Mr. Chairman. Committee, I appreciate this. I bring you House Bill 291. You've heard this before, you've seen it before. It concerns our community health workers. It simply establishes a foundation and ability to develop a structure for those who provide healthcare assistance in our local communities. You've heard this before. It was passed out last year. It's a good bill. It identifies who and what a community health worker is. It outlines who can and who cannot. Again, it's the bill you've heard before. It's a vehicle really to build a program. And it's going to bring the healthcare resources to our rural and underserved area. It aligns very strongly with the Department of Public Health's current strategic plan to increase our skilled public workforce to help meet our state's needs. It's going to standardize who and what a community health worker is. We already have several hospitals, Grady and Emory use them already, our FQHCs do. This is going to be a good way to help give that guiding hand that we need. It's going to be providing a certification for these workers. It's going to enhance our workforce, but it's another way for healthcare resources in our rural and underserved areas to help.
Thank you. Thank you,
That's it.
Chair Lady Taylor. Would you mind just going through the education that they have to have?
It's going to be established in the program. I will tell you from last year, there have been two changes. One, because it was a 2025 bill, we've updated it a year to make that. And because there had been some concern about checking out and getting certification, we've included a background check that includes fingerprints.
Fingerprint,
Yeah.
FBI check.
Yes, that's
Gotcha.
right.
So if you
Put
have
that in.
someone in your home, ought to be
Yeah,
ought to be
that's
background
exactly
check.
right. That was in consultation with Department of Community Health and members of the committee. So I appreciated that.
Okay, thank you.
And I am working off of, let's make sure we get it's LC 5702557S.
No, we're on LC 600349S. Get a new one every year.
This is a new one. I just got it several weeks ago and it was supposed to have been delivered to your office. I think this is the most recent one. Maybe not. Let me make sure. Because I've got several versions of it.
This is the one we've got right here.
Okay.
It's a 6.
60. I have this one too. Let's just make sure it includes everything that this one does. The only changes were the fingerprint. Okay. Okay. Is that the right date? Yes. Yes, it's the right one. You have the right one. You have the right one. The updated dates on it.
What was that?
Yes, that's the correct one. Yeah,
We have the right one, LC 600349S.
that's correct.
Okay, great. And we were at, have we made a motion yet?
Thank
Had
you.
made a motion. Motion by Senator Halpern. Any second? Second by Senator Harrell. And any further discussion? All those in favor say aye. All those opposed, like sign. Thank you. It passes unanimously. And who is carrying that for you?
Senator Anna Vitarte.
Anna Vitarte.
Yes.
Okay, great.
Thank you.
The leader. All righty, so thank you, Chair Lee Taylor. House Bill 334. Representative Crawford. Stage is yours. And this has changed a little bit, right?
It has,
Yeah.
and thank you, Chairman. It has changed slightly, and I can go through some of the changes.
Just, if you don't mind briefly, I think it's not too complicated.
Yes, thank you. I'm looking at LC number 521115S.
Gotcha.
All right, the bill now contains a provision that helps people that are children that are impacted by RSV, better known as respiratory syncytial virus. And RSV is a leading cause of hospitalization among infants in the U.S. There are multiple stages, which the worst stage can lead to lung infections. And what this first portion would do is require learning centers and family child centers, if a child has RSV, to properly give that information to parents so that parents will be aware of any children in that child care facility with RSV. So the parents will now have an opportunity to protect their children with that information. The second portion of this bill goes in section 2, starting at line 20, addresses sickle cell disease. Sickle cell disease is an inherited blood disorder that impacts multiple people in our state, approximately 15,000. And research shows that there's someone in every county in this state impacted by sickle cell. It is when the blood creates a sickle or a crescent shaped red blood cell, making it hard for blood to flow throughout the body, that can negatively impact organs and reduce life expectancy. What I'm asking in section 2 is for the Department of Community Health to conduct an annual review of the medications and treatments available for people impacted by sickle cell, so that we can have more input as medications and treatments evolve. The Department of Community Health has already heard this legislation. They support the legislation after hearing it, and that's really the bulk of the bill.
Thank you so much. Have a question.
Well, it's really a comment. I just wanted to give a shout out to Senator Harbison. He chaired the study committee on sickle cell disease and has worked on this tirelessly the whole time he's been here. So I just wanted to be sure that we recognize that.
Thank you.
Any further questions to have a motion? Was that a motion?
Motion I move to pass.
Right. Thanks, Senator Orion.
Mhm.
All right. Senator Merritt, second. And any further discussion?
I just want to make a comment. I did have a niece, and on her first birthday was hospitalized, because that can kill. That's, I mean, I really applaud both aspects of your bill.
Okay. Thank you.
Thank you.
Any, all those in favor say aye. All those opposed, same sign. Passes unanimously.
Thank you.
And who
Thank
was
you, Chair.
going to carry that for you?
I have a few requests of people who may be interested in carrying it out.
Oh, okay.
Harbison, or even Senator Kirkpatrick, would you be?
Senator Harbison.
Harbison or
Senator Harbison would be
Kirkpatrick,
great, really. I think that'd be great.
Yeah.
Okay, Senator Harbison.
Harbison would probably get passed pretty easily if he gets Senator Harbison.
Yes.
I don't know. I mean, I know the rules chairman is here, but you know, yeah. Okay, all right. Okay, thank you. If you could just get the information to him and little details, that'd be great.
Will
Yeah, let him know.
Will do. Thank you all very much.
Thank you.
Thank you.
Thank you, Representative. Appreciate it. All right, so we're at 6:57, Representative Hagan, yes, and all right, and let's make sure we get the LC. I got LC 6000359S.
Yes, sir, Mr. Chairman, that's the one I have here.
Okay.
And I'll be as brief as possible, but if you want me to go into more detail, just let me know.
Don't worry.
So Georgia is a national leader when it comes to supporting our neighbors in recovery. And in fact, Georgia now has the most recovery community organizations of any state in the country. We were second to Texas last year, but we've surpassed them in the past year. So this bill is necessary to protect the integrity of these life-saving programs. The sub incorporates SB 440. So I will be happy to just go over the 4 pages that are this original language quickly and then pass that off to you. Yes, ma'am. Okay,
That's fine.
so what this bill does is it defines certified peer specialists and the different types of certified peer specialists. And it also states that a DBHDD approved certified training body would need to train those peer specialists. It sets out recovery community organizations' basic operating requirements. And we want these RCOs to retain their unique character. They're all different, and that's important so that they can be as relevant and welcoming and supportive to the people in their particular communities. But we also want to make sure that they're providing consistent care and support. So that is why the request for this legislation was made by the RCOs. And the bill then says that DBHDD shall designate a statewide RCO to coordinate a network for all of these different RCOs.
subject to appropriations. So that's that is the bulk of
That's the-
that original portion of the bill.
Great. Do you have anything else to add?
I do not.
Okay.
I guess I need to talk about 440 briefly.
Yes. Okay.
Yeah, so the first part of the bill you've seen before, and we passed it already. It was Senate Bill 440, which is a Department of Public Health agency cleanup bill. We passed it, a long time ago. It went over to the House. They amended it. And I got word from the governor's office that the governor's office is opposed to amending an agency bill. And so this bill is back to as riding along with your bill.
And I'm happy for it to do that.
All right.
Yes, ma'am.
Any questions? Have a motion. So moved, Senator Sassler, Senator Robertson, the whip, and no further discussion. All those in favor say aye. All those opposed, like sign, passes unanimously. Thank you. Representative Hagan. Who was carrying that? That would probably be likely, or somebody over here.
Senator Brass
Oh,
was
Senator-
originally going to carry it simply
Okay.
because he's got one of the largest RCOs in his.
No, I think
committee.
that's a good person, especially at the end of the year here.
Yes, I thought it might be as well.
Great. And
Thank
it's
you.
agency bill, he's sort of sensitive to those agency bills. Gotcha. Okay.
Thank you.
Thank you so much. Appreciate it. Thank you for bearing with us with time wise. All right, we're down to the last bill. So because we've done the other two at the bottom and one was canceled, and the last one actually is Representative Kelly's, and he was not able to make it tonight. This basically expands the national organizations for guidelines and recommendations. You can see there in the summary and analysis. But a big story is that for colon cancer screening, colorectal screening is obviously colonoscopy is the gold standard. It has dropped down to age 45, maybe 2 or 3 years ago, and because of the increased incidence of colon cancer at younger ages. So it dropped from 50 to 45. And they're now, the gold standard has been colonoscopy. The next one has been Cologuard. And there's still some people who don't want to do the colonoscopy and don't want to do that in full knowledge that it saves lives, and there's good data and obviously good experience. There's a blood test now that is available that has a sensitivity and specificity that is certainly not as good as a colonoscopy or Cologuard, but it's really pretty close. It does meet the criteria, and it's a New England Journal of Medicine article that we reviewed, and it has good numbers. So the sensitivity specificity is in the 80s and 90s, and is good. So that's why I agreed to present the bill and have the bill on our committee. So any questions on that? Chairman Hufstetler.
Yeah, thank you, Mr. Chairman. I just want to say, when you get a House lawyer to present a bill that's only 19 lines long, then I think we should vote for it.
That is, there's something to be said about that. Yes, yes.
Yes, and just one comment about that. This bill is not to say that people that are high risk for colon cancer, they're likely going to need a colonoscopy. So I don't think the bill would.
Right. So this references the several different societies, especially United States Preventive Task Force, which is really the one that we go to and usually is what's looked to. So she's absolutely correct. High risk individuals, those who've had polyps before, those who have family history, first degree relative with colon cancer and so forth, not eligible to have anything else but colonoscopy, including this blood test.
Now, they're more column.
The colonoscopies, they are, yes, they're absolutely.
At the appropriate
The
time.
guy to your left is, does the anesthesia that makes them much more tolerable. That's right, absolutely. They feel nothing when they're around, Chairman Hufstetler.
Make a motion.
We're making the motion.
Yeah.
Do pass, and second by anybody you want to pick. All those in favor say aye. All those opposed, like sign, passes unanimously. That's our last meeting. Thank you for being here. It is 8:24. Thanks for everybody for hanging around. I really appreciate that. Thank you.